Good morning. Very fantastic judgment I am going to share with you. The accused who was convicted for an offence of 302, 436, 326A. The court below believed the dying declaration of deceased. There were two dying declaration of two deceased. And a death sentence was awarded. Therefore, according to CRPC, if the lower court, Sessions Court, convicts the accused for death sentence, it should be referred to High Court for confirmation. So it was argued that the trial commences at the Sessions Court and on reference ends at the High Court. Therefore, in case of Jayaprakash 9 murder case and bank murder case, Georgetown bank murder case, Bangalorean, it was argued that the trial commences from the Sessions Court and ends at High Court. Therefore, the appeal before the Supreme Court automatically a right of appeal. So, in limine dismissal of that appeal is against the fair trial. However, that was negativated, not properly answered because of the gravity of the offence. Here, same thing, the Supreme Court has, after going through the evidence, acquitted the appellant. The reasons for acquitting appellants was that the two dying declarations not inspired the confidence and the evidence of PW2 and PW4 are not consistent. So leave about all those things. The history was stated at para 5, go through the history, and para 18 they have tabulated the documents, evidence and other particulars. My endeavor that so far dying declarations are concerned, the judgment delivered by Justice B.R. Gawai, B. Badriwala and Prasant Kumar Misra. Judgment was delivered by Badriwala. Therefore, he strained much to invite you, law students, research scholars and the aspirings, what the other text and the judgments says about dying declaration. They referred about King versus William Woodcock, King's Bench case, and they have Judge Ayer observation, what Taylor says, and Corpus Juris Secundum, volume 40, what they say on section 32 of the Indian Evidence Act says, what says about dying declaration. Then John R. Wall's American Jurist observation about a dying declaration. Then Privy Council in Neville Nembard versus Queen. Like so many cases, after dealing everything, they finally lot of cases continuously, including a recent 2005 SC 1473 of Madras case, Muthukutti case. They finally tabulated this should be the question should be answered when the court to believe dying declaration. Before that they say, see, dying declaration is not on oath, making the person to understand that he is bound to speak truth before the court. Dying declaration is on a different table. They have tabulated 11 questions. Number 1, whether person making the statement was in expectation of death. Number 2, whether the dying declaration made at the earliest opportunity. Number 3, whether there was any reasonable suspicion to believe the dying declaration was put in the mouth of the dying person. Then whether dying declaration was a product of prompting, tutoring, leading at the instance of police or any interested party. Then whether the statement was not recorded properly, whether dying declarant had opportunity to clearly observe the incident, whether dying declaration has been consistent throughout, whether the dying declaration itself is manifestation, fiction of dying person, imagination of what he thinks transpired, then whether the dying declaration was itself voluntary. In case of multiple dying declaration, whether first one inspired truth and consistent with other dying declaration. Finally, whether as per injuries would have been impossible for the deceased to make dying declaration. The question of injuries plays a vital role. And so far the burn injuries are concerned, the doctor may give opinion about the percentage of injuries. That does not mean 100% fire injuries. Does not mean that injuries are very serious. So far these fire injuries are concerned, it is being given opinion only depends upon the parts. If the entire parts, head to feet, is burned all over this 100%. Suppose only head, that percentage is very small. But that one particular injury may cause the death of as a disease by septicemia. So the other cases referred in these cases, there are multiple cases where wife giving dying declaration and other what reasons they are giving dying declaration, to take revenge upon the person or not, all those things are there. So this is a very good case. Case was acquitted. So at the time of conducting, Justice Krishna J. Iyer in Dharamdas Vadavani state of Uttar Pradesh, that rule of benefit of reasonable doubt does not imply a frail willow bending to every whiff of hesitancy. Judges are made of sterner stuff and must make practical view of the legitimate interference flowing from the evidence. Circumstantial or direct. Even applying this principle, we have a doubt as regards complicity of appellant convict in the crime. That was his observation. See, normally when we used to discuss Justice Sundaram J, he was co-practitioner, used to say to read Justice Krishna J judgment, our teeth will be broken. Such a fantastic English wordings are being used by Justice Krishna J. So already he lived for 100 years and long history is there. And we are recently now coming across such a few judgments, not almost all judgment. This is what, this is what they say, what is maybe, must be, proved, true or must be true. These words playing is vital for defending the accusation. Therefore, at the time of, this is what I am saying, if suppose a person in fire injuries, after postmortem, lot of carbons particles would be available at vocal tube, lungs, so many. So you can very well put a question to the lawyer that under these circumstances, whether a person who sustained these sort of injuries inhaled the smoke due to fire accident or fire assault, possibilities to speak diligently, that question you may ask the doctor. Sometimes doctor may say may not be, but it depends upon the earlier death. If suppose in given cases some only one died immediately, the other one did not die immediately, even one died day after, so there is possibility of non-deduction of these carbon particles. But if any person dies instantaneously, immediately after sustaining fire injuries, if removed to hospital, and there after giving claiming prosecution may claim that he gave dying declaration, and subsequently died. And under that case, you can very well go through the postmortem report about the particles, carbon particles or smoke particles, whatever it may. It depends upon the skill of the defense lawyer. Best wishes.